All right, let's get back to our regular programming. Donald Trump's case in Washington, D.C. being prosecuted by Jack Smith for his efforts to overturn the election. Within that case, a week ago, Jack Smith filed a motion to ensure that extrajudicial statements do not prejudice these proceedings. Donald Trump immediately framed this as a gag order. First of all, it's not an order, it's a motion. The court hasn't ruled on it yet. There is no order on this motion. Terminology, what are extrajudicial statements? Those are statements that are simply made outside of the courtroom, made outside of the context of a trial. His Truth Social posts, what he says during interviews with the media, what he says during campaign stops. Those are all extrajudicial statements. They are outside of the judicial system. And so I'm going to do this in two parts. First, I'm going to talk a little bit about what he's asking for in this motion, and then what this motion means, how we should view it, how we should think about it. So just the first part of the first paragraph here. Since the grand jury returned an indictment in this case, the defendant has repeatedly and widely disseminated public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Through his statements, the defendant threatens to undermine the integrity of these proceedings and prejudice the jury pool in contravention of the undeviating rule that in our justice system, a jury's verdict is to be induced only by evidence and argument in open court and not by any outside influence. So he's saying Donald Trump is out here saying X, Y, and Z. It's attacking potential jurors, the court, prosecutor, prospective witnesses. He's trying to intimidate or influence all of those parties before a trial has even started. So what does Jack Smith want the court to do about this? The government requests that the court take the following immediate measures to ensure the due administration of justice and a fair and impartial jury. 1. Enter a narrowly tailored order pursuant to Local Criminal Rule 57.7c that restricts certain prejudicial extrajudicial statements. Say that 10 times fast. And 2, enter an order through which the court can ensure that if either party conducts a jury study involving contact with the citizens of the district, the jury study is conducted in a way that will not prejudice the jury pool. Okay. So again, it's like this is not a gag order. It's essentially asking the court to enforce an order that's already got in place. And in the first, I think it was the very first pretrial order that Judge Chutkan issued, contained language that you're not to do X, Y, and Z. You're not to intimidate, threaten, or try to influence potential jurors, prosecutors, court personnel, or witnesses in the case. And Jack Smith is simply asking the court to enforce that order. The motion itself, it contains everything you expect it to. A bunch of his Truth Social posts, quotes from interviews, things like that, demonstrating a pattern of practice on the part of Donald Trump to engage in speech, engage in behavior that can very reasonably be viewed as threatening or intimidating towards judges, court personnel, prosecutors, witnesses, and potential jurors in these cases. Now, I think the most important thing that Jack Smith is doing with this motion is he's establishing a record. What does that mean? Well, anytime a case goes up on appeal, there's an official record that was generated in the trial court. Okay? And I talked a little bit yesterday, in the federal court system, you have the district courts where trials take place. And then you have the circuit courts where the first round of appeals takes place. And then you have the Supreme Court. Well, the circuit court and the Supreme Court are only going to review the official record that was generated by the trial court. Well, now Trump's Truth Social posts are part of the official record. Circuit court judges are not going to hear appellate argument in a case and then go get on their computers and look up Trump's Truth Social stuff. They're only going to look at the official record. And so Jack Smith has to make this stuff part of the official record. Step one. Any other defendant saying this stuff would be in jail. Period. He's not any other defendant. He's a 300-pound gorilla in the room smashing stuff against the walls. And he's running for president, and he got 71 million votes in 2020. He's not a typical defendant. That's not to say he has more First Amendment rights than other defendants, but his arguments on behalf of his First Amendment rights are going to be different than anybody else's. And the court needs to take that into consideration. All of this is entirely unprecedented. It is completely unprecedented. None of this has ever happened before. And Judge Chutkan and Jack Smith need to take that into consideration as well, because this stuff is going to go up on appeal. It just is. A lot of this stuff is going to within this case. So what's the actual remedy that Jack Smith is asking for, and what's the actual remedy that Judge Chutkan would actually consider in this case? Well, she telegraphed that at one of the first hearings in this case, when she made the statement basically along the lines of, your client's doing X, Y, and Z, the remedy for that is, if he's not going to stop doing that, then we need to move the trial date up sooner in time. And, because issuing monetary sanctions for behavior like this means nothing to Donald Trump. And I think it's very unlikely that any of these judges is actually going to put him in jail while the presidential campaign is going on. So, but having the potential remedy of moving the trial date up is significant. That is not something Donald Trump wants. Current trial date is March 4th, 2024. Jack Smith had wanted a trial date of January 2nd, 2024. So one potential remedy she has is, she's like, okay, if your client's not going to stop saying stuff like this, then I'm moving the trial to January 2nd, which would cause, another freak out on Truth Social. So again, the motion itself, it's just receipts. It's Jack Smith bringing the receipts of things that Donald Trump has said and stuff that he's posted online for the purpose of making it part of the official court record, because it's going to go up on appeal. These are going to go in steps. We're going to see several motions like this, because at the first hearing, I'm guessing the judge is going to, give him a stern talking to and say, you're not allowed to do these things. And if you continue to do these things, there are going to be penalties. And she will issue an order reiterating her first order, and he will defy and violate that order. And then we'll be right back where we were. And so it's going to go in steps. And partly because Jack Smith and Judge Chutkan, first of all, they need to appear to be reasonable, which is, the defendant is Donald Trump, and they have to appear to be reasonable. Yeah, they do, actually. It'll behoove her at the appellate level if she shows a pattern of some leniency at this stage before she really ramps up penalties and does something like move the trial date ahead 2 months. She needs to demonstrate that she's operating within her discretion as a judge and operating in a reasonable manner within her discretion as a judge. Because, it's like Trump has a record of getting people to do illegal things and lie, including his attorneys. And so Jack Smith and the judge are going to give Donald Trump ample time to do things like that so that Jack Smith can make all that part of the record before he says, okay, we've been here 4 times. I'm asking you to move the trial date up. So that's how to view this document. And in the next TikTok, I will talk about the document itself.